You want to start, or I can start, whatever makes you most comfortable.
You could start because I'm like whenever you ask me to come up, I'm always gonna come up because I
Right.
was in the middle of recording, so I gotta pull up and get myself switch gears. But you started, and then
What time you going live?
I don't think I'm going live today. I'm just recording videos.
Okay, okay. Well,
Yeah,
yeah, I'll start, but
you start and I'll follow.
okay, appreciate it. So claim 5, prior convictions, enhancements. Petitioner submits this claim on the pleadings. F, claim 6, newly discovered evidence. 1, statement of relevant facts. On May 26, 2020, a civil trial commenced in the Los Angeles Superior Court in, and then it does have a footnote, the denial of 3 prior requests for substitution of counsel were found not to violate the Sixth Amendment right to counsel of one's choice. And then they cite the case. But as I was, LA Superior Court in the case of Lillian Carter, inter alia versus Universal Studios, Inc. Wait, what page was that? Yeah, that's 31. All right. And then the case number. Before Honorable Thomas D. Long, the sole defendant at this trial was Mr. Knight, Exhibit 10. A. Carl Beals. Mr. Beals, a human factors and safety expert specializing in accident investigations, testified for the plaintiff. He said that at the time of the incident, there were no conditions that made it difficult for Mr. Knight to see pedestrians, that although there were or may have been some blockage of his vision from the hood of the truck, there were no significant obstructions to the driver's line of the sight. As to Mr. Carter, rest in peace to Mr. Carter, that there were no internal distractions, and the external distractions, i.e. the recent fight, could not account for the incident. I think that's fraud. He's wrong, totally. That the locations of the pedestrians was not unexpected, that there were no avoidance maneuvers by Mr. Knight. There was no indication he did not have control of the vehicle, that it was not unusual for Carter and Sloan to be where they were hit, and they could not have moved out of the way. Exhibit 32. On cross-examination, Bills testified that he had no expertise in tachypsychia, a neurological condition that distorts the perception of time, that the front of Mr. Knight's truck was about 4 feet off the ground, that Carter may have been bent over at the waist when he was struck, that Carter was not clearly on the sidewalk when he was hit, but was partially on the driveway, that he did not know if the truck had a lift kit, which would make the height of the hood higher than 4 feet, that at the point of contact with both men, Mr. Knight was coming up an incline of a driveway, which would make the hood still higher, and the truck's front wheels would have been higher than the back wheels and would have tilted the front of the vehicle upwards. ID at page 35 and 36, that he did not know how the driver's seat was adjusted at the time. Another footnote, the complaint for damages, personal injury, filed June 3rd, 2015, alleges 1, wrongful death negligence, 2, negligence, 3, negligent entrustment, 4, assault and battery, 5, negligent hiring, retention, and supervision, and 6, premises liability, see Exhibit 33. But that basically they're saying this fake specialist didn't know how the driver's seat was adjusted at the time of the incident, that he did not know about a scientific investigation report by Dr. Thomas Guzman regarding the incident, that an external distraction would exist if Mr. Knight was punched several times by the man standing at the open front passenger side window, who could have had an iron plate in his fist. ID at 39, that Sloan could have been hit by the large rearview mirror of the driver's side of the truck. ID at page 3045, that if Mr. Knight saw a gun in Sloan's hand as Sloan approached the truck, this could be an external distraction, as could Mr. Knight's belief there was a contract on his life and the situation might be an ambush. ID at 41. Bill admitted he was not an expert on post-traumatic stress disorder, the concept of fight or flight, or the effect of these disorders on one's ability to safely control a vehicle. ID at pages 41 through 42, 55 through 56. Nor did he know whether Mr. Knight suffered from glaucoma, had lost substantial, if not most, of the vision in his left eye, and had reduced vision in his right eye. ID at 50 through 51. Marion Hugh Knight Jr. Mr. Knight testified on June 8, 2022. See Exhibit 34. In 2014, the FBI, regular police, and people in the music industry told him there was a contract out on his life. After learning this, he was ambushed and shot 7 times at the One Oak Club in West Hollywood on August 24th, 2014. He was hospitalized at Cedars-Sinai Hospital, but checked out after about 3 days because it seemed like anyone could come into his room and he did not feel safe. Mr. Knight was depicted in the movie Straight Outta Compton and was told early on he would be compensated for the use of his name and likeness. ID 10 through 11. On January 29, 2015, he drove his truck, which had a special lift kit and large wheels that made it higher than normal, to base camp to talk to Andre Young, Dr. Dre, or Dre, to let him know that the authorities were saying Dre had paid someone to have him shot. 25, Base Camp was the name of a staging point for the production of a commercial for Straight Outta Compton that was located at 700 North Bullis Road, Compton, California. He didn't see anyone around and decided to drive away. Then he saw Knob, who confirmed that Dre was busy. As he was leaving, 3 guys ran over to him and said, Cube. Ice Cube wanted to make sure he came to his trailer because he had been trying to catch up with him to take care of him. ID at 12 through 13. A sergeant pulled up and said he had been called to find out what was on Suge's mind. ID at 13 through 14. At this point, Clee Sloan Bone came over to his truck. They had a conversation, but when Mr. Knight referred to Bone's white Rolls Royce, Bone seemed to take it as a sign of disrespect, and they exchanged words. Mr. Knight left base camp over 15 or 20 minutes. Soon after, he got a call from Terry Carter, who told him Dre was going to Knob's house and asked Suge to meet him there. Mr. Knight described Mr. Carter as a smart guy who had his stuff together, could be counted on, and someone he respected. ID at 17 through 19. He and Terry Carter were friends. He had paid Carter's mortgage before, and Carter had 2 of Mr. Knight's cars worth over $200,000. He described Terry Carter's debt as a burden I carry on me like a weight this whole entire time. Mr. Knight drove to Knob's house, which is right by Tamsburger, expecting there would be a conversation about paying him using his name and image in Straight Outta Compton. He saw Carter's gray station wagon parked eastbound on 142nd and pulled beside it facing westbound. ID at 48. At the time, Terry was reaching towards the passenger seat, sort of grabbing something. ID at 43. At the same time, he noticed some guys standing in the road on the curb nearby, and he drove a little bit toward them and stopped. He knew these guys had guns. ID at 20 and 43. These guys tried to engage him in conversation. Then he saw Bone hop over the fence at Tams. ID at 21 and 44. Bone came to the driver's side of his truck, brandishing a gun at him. ID 22 through 23, 49. Mr. Knight was scared and tried to convince Bone he had no reason to kill him. And he also heard people shouting, "Don't kill him," in the car. Bone was swinging at him through the open driver's window. Mr. Knight accelerated to go straight, but Bone was behind him, and Central was blocked off by some guys so that if he went straight, he would run into them. ID at 51. There was also a guy behind him on 140th, which meant that both streets were blocked off. ID 24 and page 26. He made exhibit 24 and 26. He made a left turn towards Tam, but when he saw people heading towards Tam, he stopped, put his wheels back the other way, and drew it through his truck in reverse. Bone again was hitting him through the driver's door, and he tried to get the truck's keys. And there were people on the passenger side trying to get Mr. Knight out of the truck. He put the truck in drive, trying to go straight, but then did not go straight back. Mr. Knight later found out that Bone had thrown it in reverse. ID at 25. Mr. Knight was afraid and everything was happening fast. The only thing he could do is put the truck in drive and go straight. He drove through Tams and out the other side. I bid people were following him when he left Tams until he sped up to get on the freeway. He did not know he had hit anyone until later that day. At the time this happened, Mr. Knight was 100% blind in his left eye, and he could not see to his left when facing forward. To see left, he had to turn his head to the left. ID at 28 and 59. He cannot see to his left when he faces forward, only if he turns his head towards the left. In addition, he was afraid because Bone and others were trying to kill, traumatized by, and still healing from having been shot, had lost 40 pounds and was in pain. Mr. Knight turned himself in on the murder and attempted murder charges in the early morning hours of January 30th, 2015, ID at 29. While confined at Men's Central Jail in downtown Los Angeles, he could not get incoming mail, visits, or make outgoing telephone calls. If he wanted to hire an attorney to represent him in a criminal case, he had to get the approval of the Los Angeles District Attorney, Los Angeles County Counsel, the attorney for the Los Angeles Sheriff Department, and the judge for a visit by an attorney. More specifically, an attorney had to file a motion to be allowed to visit him, serve the motion on the prosecutor and county counsel, and the judge will rule on whether the attorney could have one visit with him. He was not allowed to make telephone calls to or write to an attorney regarding representation in this case without the approval of the prosecution, the attorney for the sheriff's department, and the judge. He had the right to hire an attorney, but could not do so because he could not talk to an attorney. As a result, it was almost impossible for him to hire counsel. And even when an attorney was approved for a legal visit, the visits were recorded, so there was no confidentiality. For his first days in court, he hired David Kenner to represent him, but Mr. Kenner was ill and Mr. Knight did not feel he could put him in through this case. In addition, from day one, when they started to threaten the attorneys, I couldn't put Kenner in that type of situation. Later, when Mr. Kenner was feeling better, he wanted to bring him back on the case, but Kenner could not see me without them recording me. Mr. Kenner asked for an unrecorded attorney-client visit with him, but the judge did not allow it. Exhibit at a visit with an attorney that was recorded and listened to by the prosecution would not have done him any good. He met most of the attorneys who appeared in this case at the jail attorney visiting room. He went to junior high school with Matthew Fletcher and started talking to him when he saw him at the jail. Another attorney he met told him he would get some attorneys who worked with him to come by court and talk to him. Thaddeus Culpepper was just another guy who came to talk to Mr. Knight. He knew Jamal Tucson from when he was a sports act. He tried to hire David Shenfield and Richard Scheinfield from Las Vegas, but every time they would come to the jail, they would have to sit for hours waiting for him to come to the visitor room, and they never really got a chance to talk. Mr. Knight was allowed a visit by an attorney named Sean Byers, who talked to him for 20 minutes and did not return. He hired another attorney he met in the attorney visiting room, Dominique Banos, but they told him she was not qualified to represent him. Judge Cohen gave him an attorney, Albert DeBlanc, whom the judge had known for 40 years. So this sounds like a lineup, honestly, right? The judge know this lawyer for 40 years, and he said, well, you can't pay for the attorneys you want, but I got a lawyer for you, right? Mr. Knight saw DeBlanc at the jail twice for a total of 8 to 10 minutes. When trial was scheduled to begin in mid-September 2018, DeBlanc told him he was going to continue the trial so he could learn Mr. Knight's case, but he did not obtain a continuance. Right before trial, DeBlanc told him that he did not get a chance to know the case, that because he did not know the case, Mr. Knight would lose if he went to trial, and that if he lost, he would be sentenced to 100 years to life in prison, and he would die in prison. DeBlanc told him the best thing to do was to take a deal. If he took a deal, his 2 other cases would be dismissed, the murder charge would be reduced to manslaughter, and because of his age and other things, he would get out soon. The sentence would be 11 years, the high term for manslaughter, and if Mr. Knight did not have a prior strike, he would be out shortly. During the entry of his plea, after the judge informed Mr. Knight of the consequences of the strike priors and asked if he admitted the priors, Mr. Knight and DeBlanc had a private conversation. DeBlanc told him he had been doing this for 40 years, that he would go into chambers away from the cameras and get it straight that he would not have a strike and it would be taken care of, no problem. You have my word on that. ID at 3738. DeBlanc said he guaranteed that he could fix it, so he should say yes, agree to the strike. At sentencing, Mr. Knight's 11-year sentence for manslaughter was enhanced by 16 years for priors. He is serving 28 years, a 28-year sentence. At the time this happened, Mr. Knight's mother had died after she suffered a stroke, leaving the jail, where she had been refused a visit with him. Mr. Knight was pretty much down after that. Mr. Knight did not see the discovery in his case, even to file an appeal, because he was told there was a protective order. Marvin Kincey. So we interviewed Ayatollah Marv, and we talked about this, but I want to break this down. That would be my worst nightmare, to be in jail and to lose my mom. You know what I'm saying? And she came to visit me the day before, not being able to be there to carry her and lay her to rest. You know what I'm saying?
That's a tough pill.
Yeah, that's a tough pill. And obviously he know what he was getting himself into. He in the streets and in the music industry, and you accept what come with it. But in this situation, it sounds more like he was targeted and lined up. They utilize, if you've seen Straight Outta Compton, the movie, and we're gonna get into this. We're gonna get into this chat. Everybody hit that like button. Them likes do not look good. We got 160 people in here, man. But if you watch Straight Outta Compton, they had a big old dude, I think he's a Crip, playing Suge, utilizing the image of Suge in this story, right? Of Straight Outta Compton and the role that he played in real life. So if that's true, and he comes up there and he's trying to be compensated, he was told he would be compensated, and he talked to Terry Carter. Terry Carter, somebody he said he trusted, who has 2 of his cars, and he comes in, he's talking to Terry Carter, and he sees what appears to be an ambush. LAPD already told him, and the FBI already told him that he had hits on his life, right? Oh, I'm so sorry. Let me fix it. I just seen it. Right. Let me fix it. Let me go back up. Where are we at? Oh, we're going to take that off.
So what else? So when they did the Straight Outta Compton movie, a lot of that stuff is going to be in this paperwork?
Well, they definitely finna talk about it because it was on the shooting of the Straight Outta Compton movie. A lot of those dudes, I don't know, like everywhere else, but one good thing about the gang subculture that they have is structure. We don't allow people to come into our communities and generate tons of money without including those within the community. And we press those type of lines. We territorial. We come from the gutter, and these is resources that we need. So Suge know the game. They use my image. I need to be compensated. Give me a bag. They said they're gonna give it to him, even though he's being told that Dr. Dre got a hit on him. This is what he's saying that the FBI and LAPD told him. Mind you, he had just been shot at 1-0.
Right.
Salute to 1-0, one of the populous clubs in LA. And but he's still going up there, man. I'm going to get my money. If they go, if they go get me, they go get me. But I need this bag. You know what I'm saying? And obviously, Cleabone Sloan had an issue. He definitely played a major part in hiring other people for Straight Outta Compton. In fact, one of the dudes he hired for Straight Outta Compton was a dude named D-Dog. And D-Dog was recording Cleabone for, I think, 3 days without him knowing. I'm in the car with you. You done gave me a job, and I'm recording you while you talking on the phone. You could be, go pick up them birds up over there. You know what I'm saying? Oh, yeah, fuck that nigga. That's why the homie whoop-de-whoops killed that nigga. And he's recording for 3 days. Nasty work. I kicked him off my stage on Clubhouse before when he came, right? But he was hired by Cleabone Sloan, right? So Cleabone Sloan, and he was alleging that Jimmy Iovine and Dr. Dre were so terrified of Suge Knight that they had put a hit on Suge, and that's what Cleabone was trying to do, right? So with that being said, I was like, okay, I get that. And them dudes is civilians. So you deal with civilians how you deal with civilians, right? Neither one of them agreed to do crimes with you. How civilians going to deal with you? So I was thinking about that, but then he started talking about some other murders. I'm like, bro, wait, you recorded this dude for 3 days. He's talking about murders and all of that. What was your intent to do with those things? Oh, I wanted to give it to the district attorney so that I could help Suge. And this, I'm like, man, get up out of here.
That don't even sound right. Like, you sound corny.
Right. So I got him up out of there. But as said before we get to Ayatollah Marv and his testimony at the civil trial, it appears that Bone definitely had an issue and approached Suge Knight with an issue. It's alleged that Bone, in his paperwork, that Bone brandished and dropped the gun, right? And Suge is trying to get the hell out of there.
Right.
The streets is blocked off because there's so many people out there. The movie shoot for Straight Outta Compton, and he can't get his way out, but he's being punched. You clearly see that on the He says he sees a gun. It's being alleged that he sees a gun and that he believes someone was trying to unalive him. So
1 + 1 is 2.
Right. Remember, his left side is 100% blind.
Right.
So he's driving. On top of that, he's in this big old, I think it's, I don't know if it's a K5 Blazer or what kind of Blazer that was, a Raptor or something, right? And it was altered, so it's even higher than standard, right? So he's partially blind out this side. He's worried and scared. The being punched could be with brass knuckles or a weapon or just fists, and probably dazed and panicking because he's in fear, and he's trying to get the hell out of there.
Right.
He says that Bone is the one that put the car in back. So if he hits somebody while he's backing up it wasn't necessarily him that ran the person over because he didn't put it in reverse.
That's
right?
true.
So this is, from a legal standpoint, this brings a lot of clarity to a situation and an experience that the average person has never been through. We could say what we would have done in this situation, and you don't never know what you're going to do in these type of situations until you're in those situations.
That's a fact. That's a whole fact.
Anything you want to add to that before I get to read about Marvin?
No, you broke that down so perfectly.
Okay. Well, I see them. Let's get into some of these comments because I want to see what they saying. Bobby Burnett said, "What it do, Henny in the chat?"
What's poppin'?
Henny got fans. Okay. Hey, Henny. Hey, we doing that. We finna set this. What you call it up? Wait till we finish putting together this tour and stuff we working on. We finna get Airbnb for about 10 days, and we gonna have a show where we gonna get all contestants that are interested in dating the queen, and we gonna get y'all in one place, and it's gonna be a elimination, right? And y'all, and I'm telling y'all now, we're gonna be interactive on social media, reacting to the episodes, and we're gonna be voting on people who we do and don't like. You know what I'm saying? And we're gonna be able to monitor the analytics to see who we ain't feeling. And if Henny pick them, I'm just gonna keep it G. If Henny pick the dude that we ain't feeling, we just gonna have to pack that nigga out, y'all. We ain't gonna let him go through that again. You know what I'm saying? We gonna make sure, we gonna make sure that it ain't nobody that's gonna dog Henny. You know what I'm saying, y'all?
Yeah, it's probably at work. Yeah, it's gonna be Henny versus 20. But since you put that disclaimer out there, I'm not gonna go against the grind, against the grain. Like, y'all saying no.
Ultimately, you the one that gotta go on more dates with this person and try to work it out. If he does choose you and you choose him, right?
But somebody said I was gonna sign up to that last part.
but SAC report everything, but this or Keefe D motion. I don't know. I mean, WAC report everything, but this in the Keefe D motion. Well, I think he's kind of embarrassed that not only was he trying to bail out a rat, but he was trying to bail out the biggest rat in the history known to man. Keefe D, he's a long-tail rat that's been ratting for years. But let me see.
Internationally ratting.
International rat. You know what I'm saying? Internationally known. You know what I'm saying? But of course, he ain't gonna talk about the Keefe D paperwork because once it came out, first he was embarrassed with his. How did they say it again, Henny?
The morass of false statements and rambling nonsensically.
That gotta be embarrassing. Then they said he has no credibility, right? None. I don't know how he gonna continue to be a confidential source and informant if he can't testify in court or any trials because a judge had already said he has no credibility.
Don't forget they called him broke too.
Oh, and they called him broke. Hey, listen, he's a brokey. He came to the internet being all he could be. He's this big millionaire, tried to act like he bailing out Keefe D, middlemaning someone else bailing out Keefe D, try to act like it was him and he had this big money. So when the money got to come through his account, we find out he was a brokey. So Tart Mystic says vision problems as significant as written in the paperwork would have meant Suge would have lost his license if he'd been here in Scotland. Oh, yeah. Scotland is a little bit different. Kayla, thanks, bye. Kayla, thanks, bye. Wow, how rude. You said thanks and bye.
That's her name.
Okay. Stacy Talgert. What up, brother? Salute to you today. I hope you having a wonderful day today. Stay blessed and stay safe and healthy. Always, my brother. Will bless you too, and you stay safe and healthy. Miss Poppy 10, hit that like button. Hey there, Queen Henny. How are you doing today, sweetheart? I hope you're having a wonderful day today, love. Hey, Henny, did you see Munchie B and Alex shout you out on street TV?
No, I didn't. I missed that.
Oh, Munchie B said he was sending
Really?
you the thing. I promise you. He's like, I got Selena doing something with the legal team, trying to get something that we were trying to research. And so he was like, what's up with that? I'm like, oh yeah, she just got back to me. It got lost in the shuffle. It's been a lot going on. He's like, but did Henny hear that me and Alex shouted her out on the street TV? I said, well, you know, that's nothing big for Henny. You know, Henny is Henny. You know what I'm saying?
It's not, but you know what? Every time somebody does it, it still is like, oh, y'all know me? Like, wow.
Well, yeah. Well, you know, when you get the Shade Room, Hollywood Unlocked, Street TV has over 500,000 subscribers, but it ain't even just the subscribers that Street TV has. It's the authenticity and the way that they're looked upon within our community, right? He's a journalist, a historian of Los Angeles, specifically the gang subculture, and he's a professor at USC, right? So that definitely lets you know that when y'all think it's just a Henny blog, meaning all she do is bring the tea, nah, there's a real journalistic edge in what she does. Salute Paris Todd, and salute, brother. You know what I'm saying? And she definitely is starting to get that recognition. She's definitely gonna have the receipts. Don't even think she running it if she don't got the receipts. You know what I'm saying? But let's
get to that. But thank you. I just real quick before we get back into the content, just thank you and salute to Street TV. I watch them all the time, but I'm still honored. You know what I'm saying? Even when y'all be like the queen, like I'm honored because I feel like I'm honored to be
all
here.
you see is where you at right now, but I already see where you going. See, one thing I know about it, you can't stop a shooting star, right? The universe and its energy can't stop a shooting star, right? So you're going to dwell amongst the rest of the stars, whether I'm in your life, stop you, or anyone, because that's just what the destiny is. That's what the universe has for you. I told Big U that, and Pop LQ and everybody when I first seen you. I'm like, first, your energy, right? And it's really evident, indicative of your character, the way that a lot of the Henny snipers and your supporters take to you. You get your ass beat messing with Henny. You know what I'm saying? Like, really, I'm just saying you can say something like, she ain't even combed her hair. They be trying to pull up at your house. She just woke up. She didn't comb me, but they gonna beat your ass. You know what I'm saying? So yeah, man. Salute to the Henny legal team. I mean Henny.
Oh, they gonna get you.
The Henniettes and the Henny legal team. Hey, no, I'm not the one butchering the name.
He's gonna instigate. Go ahead.
Hey, salute to the Henniettes and the Henny legal team.
Hey, Heidi B says she gotta be there. Hey, Loom Loke says she belongs to me. Look, they already.
Oh hell, here we go.
Look, Dopest TV said I was gonna sign up to that last part. Oh man. Leon Loke says sis belongs to him. Oh yeah, it's gonna go up. But I think it'll be good. Hopefully she finds some smoked out TV reaction. Henny is mine, so who want them problems?
Whoa!
Oh man!
Whoa!
It's already started. So yeah, we definitely gonna have to do it. And I'm telling you, it'll be like a 2-week vacation, right? All we have to do is make sure her bills and everything is paid up, get her out in LA for 2 weeks, 10 days really for shooting, and already have did a cast to string out dudes. Hey, do you have felonies?
Who's picking the dudes though? Is what I need to know.
Because I already know you already.
He said us.
You already told me that you like them rough. So if they ain't got no felonies, I'm an X them off the list. I don't care if he a billionaire. I'm be like, look, bro, She's gonna appreciate you having your bag together and all that, but she gets her own bag. So she's gonna need somebody that ain't a little rough on the edges. You know what I'm saying? So she can.
She don't have to be a felon. That's not true. They don't have to have an F on their record. They just got to be able to hold their own. Like, you can't be no punk.
Oh yeah. Hey, Shotgunner said, Yael, I talk to dog in my CS.
Hit the talk to dog real quick, Yael.
I talk, hey, I talk to dog. He be lying like a motherfucker. Lying like a motherfucker, bro.
Hey, I talk to dog. Hey, Yael, but what did the brother say though? When he defected, when that brother
he said, and I talked to the big dog, and he said, when that brother defected, he put emphasis on defective.
Right.
He was talking to those detectives.
Right. He definitely was. But let's get back to the content. It's a lot of reading, but I definitely wanted to bring some entertainment and some laughter to this. So now, Marvin Kincey, Ayatollah Marv testified in the civil lawsuit against Suge Knight. He testified on behalf of Suge Knight as they were trying to sue him. On June 9, 2022, Ayatollah Marv testified. The following is a summary of what he said. On January 29, 2015, he received a telephone call from dissident Terry Carter, informing him that there was an incident at base camp. Carter explained that Mr. Knight should call him, said he had been at base camp and spoken to Ice Cube's bodyguard, and that Bone, Clee Sloan, had interrupted this conversation and disrespected him in front of others who were there. Carter informed Kincey that he told Suge to meet him in front of Knobs' house at 142nd in Hilford in Compton, near Tamsburger. Kincey drove to Knobs' house and saw Terry Carter sitting in his car, which was parked across the street facing east. Kincey parked his car in front of Knobs' house and walked up to Carter's car. Carter told him that there was an argument between Suge and Bone, that Suge told Bone nothing was going to happen at base camp, but if he saw Bone on the street, they were going to have to do a head up, i.e., have a fight. So Suge is telling them, look, we at base camp, it's business out here. We not finna do no nigga shit, but when I see you in the street, we gonna run that fade, nigga. You know what I'm saying? And Carter said he told Suge to meet them at Knobs' house and that Suge was on his way there. Next, Knob arrived, pulled into his driveway, and walked to Terry's car, where Terry repeated what he had just told Kincey, which is Ayatollah Marv. As they were talking, Suge's truck turned off permanently and started coming up 142nd Street. Suge put next to Terry's car facing westbound, put his truck in park, and started talking to them about what had happened at base camp. Suge said that he went there to discuss payment with Ice Cube, whose bodyguard told him that they would send him a check. As he was getting ready to leave, Bone came over and disrespected him in front of some Crips. Suge said he told Bone he would not do anything at base camp, but if he saw Bone on the street, he was going to get at him. At this point, Bone jumped over the 2-foot wall at Tams, ran up between them, and hit Suge in the face about 5 times, yelling, "I'm going to kill you," and other profanities. Suge was just trying to get out of the way of Bone's fist, leaning to the side away from Bone, who continued to hit him. Suge put his truck in drive and pulled up into the Tam parking lot driveway. When Suge was in the apron of the parking lot, he stopped and turned around, looking at Bone. Bone ran over to Suge's truck and started jumping up because the car was then at an angle. Bone started hitting him again, but Suge never said a word and leaned away from Bone while Bone kept on saying, "I'll kill you." At this point, there were about 3 or 4 more guys who had gathered by the wall. After Bone hit Suge about 3 times, Suge put his truck in reverse and backed up. As he did so, see, this is Ayatollah Mar's rendition, and he's saying that Suge put his truck in reverse. But during Suge's testimony, Suge is saying that he didn't put it in reverse, that it was what you call it. So Ayatollah Marv is just assuming that Suge put it into reverse, not knowing that while Bone is hitting Suge, he was putting it in reverse, trying to put it in park. You see what I'm saying? So, and backed up. As he did so, the outside mirror on the driver's side hit Bone and knocked him down. At 19, Suge looked like he was going to drive eastbound on 142nd Street and was looking at all directions like he was looking for where everybody was, where Bone was. He couldn't see Bone because Bone was laying on the ground. Suge looked in his rearview mirror and he kind of froze, put his car in drive, and went back up in the parking lot. At this point, there were people milling around at 142nd and Central, including some kids coming from 142nd from school. Ayatollah Marv saw a friend of Bones named Jimmy Chris, who was parked on the median on Central, running from Central down 142nd in a crouched position. Before Jimmy Chris reached the back of Suge's vehicle, Suge put his car in drive and went back up into the parking lot, drove through the lot, and exited the other end. Mr. Ayatollah Marv was shown a video recording of the events. He identified Bone and Terry going to Suge's vehicle. He identified himself as the person in the black pants and white sweatshirt who bent over Bone and picked up a gun from Bone at 24, 25, 61. So now the video is actually showing Ayatollah Marv picking up a gun next to Bone. So these police know that the whole time Bone is coming, he not only probably punching Suge, he could be hitting him with the burner or trying to shoot at Suge.
Right.
He did not pick up a cell phone, radio, or a communication device and never put anything inside a vehicle. The only thing he picked up was a .32 Ruger handgun. Mr. Kincey, Ayatollah Marv put the gun in the back of his waistband. Bone asked him to get him out of the streets, and he did so. It was at this point that he realized Terry Carter had been hit. He called Captain Shaheed Muhammad. So, you know, Brother Ayatollah Marv is with the Fruit of Islam, the Nation of Islam. You know what I'm saying? So he called Captain Shaheed Muhammad, told him Carter had been hit by a car, and asked him to contact Carter's family. So these are friends of Terry Carter. These are people in the community who love Terry Carter, right? Mr. Kincey was cross-examined about an interview with Sergeant Biddle and testified that when he said there were no straps at the scene, he was referring to Jimmy Chris, who did not have a gun. He was questioned about an interview with a private investigator on July 26, 2016, during which he said he saw a .380 firearm in Bone's rear left pocket, that he was not sure if any weapons were removed from the scene, and that he never picked up a gun. So when the detective is asking Ayatollah Marv, was there a gun for the purposes of their investigation, he's lying to him and telling him, no, it wasn't no guns. I didn't pick up no gun. You know what I'm saying? So there was additional questioning about an interview on May 10th, 2017, during which he said Bone had a .380 in his left front pocket, but he never saw the gun in Bone's hand. He denied telling a private investigator that when Bone first hit the truck's mirror and was knocked to the ground, a .380 fell out of his pocket and was on the ground next to him. Denied that he put the firearm he picked up into his pocket, and denied lying to detectives when he was first interviewed. Ayatollah Marv testified that a statement he made to Detective Biddle on August 2018 about being done with all of that and having questioned Biddle about why he did not look into the issue earlier sounded familiar. He testified that he was not offered money and did not receive any money to testify. nor did he tell detectives Mr. Knight was a close friend whom he loved. He did not see a gun in anyone's hands during these events and did not see a gun in Bone's hand when he was punching Mr. Knight or at any point that day. Mr. Kincey testified that what happened at Tams was an assault, not a fist fight, because it takes two people to fight. He also described Suge and Terry Carter as friends who got along and were always calling each other. So now, you know, if that's your friend, he didn't intend to hurt and run over and hurt this elderly man, Terry Carter. Another rule. You know what I'm saying? Bone being hit by the rear view mirror when the car back up and he's trying to punch or bust at whatever he's trying to do to Suge, and he getting hit, shit, he deserved to get hit. You know what I'm saying? You assault me. My mama told me, if you getting hurt, beat up and you can't whoop a motherfucker, you find something, pardon my language, you
it's
find
okay.
Yeah, you find something and you pick it up and whoop a ass. You know what I'm saying? Forget what the law is talking about. At this point, I'm fearing for my life. I'm trying to get back home to my family so we can deal with the laws later. You know what I'm saying? And however that comes. But yeah, on June 16, 2022, the jury informed the court that it cannot produce 9 aligned votes on battery and negligence. So that means that it was a mistrial on the civil lawsuit. The next day, June 17, 2022, additional instructions on self-defense were given and the parties were allowed 5 minutes of supplemental closing arguments on self-defense. Afterwards, the jury requested to read back Mr. Knight's testimony about being ambushed, the definition of assailant, and Mr. Knight's testimony about how he got to base camp, right? So this is what the jury were interested in after already being in a hung jury. They said, well, go ahead and try to start back from the beginning. We're going to allow 5 minutes of supplemental closing argument by the defense and by the prosecution, right? Go ahead and start back over. So now the jury then sent notes out to the judge, and the court's telling them that they requested a read back of the transcripts of Suge's testimony about being ambushed. They asked about what is the definition of assailant, and then Mr. Knight's testimony about how he got to base camp. At the end of the day, the jurors reported they were deadlocked 7-5 on battery and negligence. The court excused the jury and ordered them to resume deliberations on the next court date, June 21st, 2022. On June 21st, 2022, the court noted that to date that there had been 16 jury notes during deliberation. He had a hell of a jury, man.
Yeah.
I know y'all don't know about it, but you get some that don't want to be there. They don't listen. Some of them aren't trained to think, and they're followers, so they're just going to go by whoever is more dominant or like an alpha who takes the lead and just, well, whatever. I'm just trying to get out of here and get back to my life. This jury was engaged. They listened. They double checked. When any person going through a trial, whether civil or criminal, could only pray if they are innocent. Or even you could be guilty of, say you charged for attempted murder, but really in true life, what you did was really just assault with a deadly weapon, right? Which is the lesser included offense, right?
Right.
You get a good jury like this, you got a real good chance at getting what you're really guilty of, and not how the prosecutors try to put the dubs on the 2, right? Put the 10 on the 20, you know what I'm saying? And you're going to get justice can be found. This dude had a great jury. Additional jury notes were sent on that date, including one stating that the jury was deadlocked on battery and negligence, 8-4. The jurors were ordered to continue deliberation. So now if you Suge and his lawyer, you like, man, fuck that. Call it a mistrial, right? Call
Right.
it a hung jury. Why you keep sending them back in there? They're tired, right? They've been listening to all it. What we just heard last night, 2 hours, and this ain't even a 10% of what they have to sit down there and listen to all day. You know what I'm saying? And now they're in deliberation, tired, ready to go home, and the judge is saying, well, y'all go back, y'all ordered to go back in there and continue deliberation. Right?
I couldn't imagine.
So on June 25th, 2022, the court responded to a 25th note from the jury, Exhibit 40. Later that day, the jury sent this 26th note stating that jurors were deadlocked on battery and negligence 7-5 now. So now it's trending in Suge way. So they probably pissed off. No, now, yo, you know what? I think y'all right. I really just wanted to get up out of here. So I went with the 8-4. But now that we had to start back over, now I'm looking at it, it went to 7-5. And now, yeah, man, if we gonna be here, we gonna get it right. They fighting for him, you know what I'm saying? And so now that it's going in Suge way, a mistrial was declared. You know what I'm saying? And then argument, respondent contends that petitioner has not stated a prima facie case that there is newly discovered evidence, and that the newly discovered evidence would not have more than likely than not change the outcome of the trial. Informal response, these arguments lack merit. In urging that the civil trial testimony is not new evidence, respondent, which is the government, cites a TMZ article dated February 11, 2015. TMZ's alleged illegal airing of a video of the homicide with a marker labeled possible gun. Wait, so TMZ was already reporting that was possible gun that fell up out of Cleabone hands or pockets or whatever, his back, the small of his back or whatever. And it seems that the prosecution didn't want that evidence out. They want to hide that from the jurors. Wow. A claim by Matthew Fletcher that Bone had a gun and ambushed Mr. Knight. A TMZ article titled Suge Knight Video of Crash Proves I'm Innocent. And yet another TMZ article titled Suge Knight's Lawyer. Both victims had guns. Informal response, page 45, footnote 52, 46. However, these TMZ articles are not evidence. The content of the articles is not admissible. The reported statements by Fletcher are not admissible. And portion of the video labeled possible gun, which apparently reflects the opinion of someone who worked for TMZ, is not admissible. The testimony, why would it not be admissible if people in the community and even the news media, the crooked news media at that, are believing that they see a gun in there? You want us to unsee what and take away our mind so that you could railroad this man?
But not only that, the video that they put up is the same video y'all are looking at. So how is it inadmissible?
Right, because they don't want to
playing in his favor.
Right. And they always want that extra edge. So the testimony at the outcome of the trial in Lillian Carter versus Universal Studios is newly discovered evidence that concern the same events at issue in the criminal case. Marvin Kincey did not testify at the preliminary hearing in the criminal case. The effort by respondent to minimize his admission that he retrieved the gun from Cleabone Sloan after he was run over is unavailing. Bone was the person who jumped over the wall from Tams, ran to Mr. Knight's truck, and repeatedly hit him through an open window on 2 separate occasions. Mr. Knight did not respond in kind to Bone's assaults on his person. Instead, he leaned away from Bone's punches and tried to leave the scene where there were numerous persons in addition to Bone that he believed were armed. the reasonableness of what he did to accomplish that end, as well as his state of mind at the time, were critical facts in determining whether this was a murder, manslaughter, a killing in the honest, but objectively unreasonable belief in the necessity to use force to defend himself against a threat of death or bodily harm, a killing in self-defense, or an accident. Here goes another footnote, number 28. Although these sources do identify investigative leads that could have been pursued based on the records available to present counsel, there was no effort to do such investigations. Competent defense. So now they're saying that his previous attorneys were incompetent. You know what I'm saying? Which all criminal defendants have a right to effective counsel, and incompetent counsel can never claim to have been effective, right? So, but that's under Strickland versus Washington, which is basically the bar that outlines what counsel and lawyers must do, their requirements, and anything less to meet that is ineffective assistance of counsel. So this is this statement about them not doing the investigative report. Failure to investigate is a one way that an attorney could be ineffective. You know what I'm saying? They have an obligation by the courts under Strickland versus Washington, U.S. Supreme Court, to investigate all reasonable lines of defense. They don't have to utilize each line of defense. They could pick which one it is. But a failure to even investigate, how do you know whether or not this is the best way to investigate, the best way to bring trial strategy and defend your client if you haven't even investigated where that will lead you, what information can bring to you? So that's incompetence, and that's what they're arguing here in the footnote. This will be addressed more fully in connection with Claim 7, which follows. In Lillian Carter versus Universal Studios, the plaintiff had the burden of proving liability by preponderance of evidence, not beyond a reasonable doubt, as is in a criminal case. I hope y'all understand that. So in a criminal case, and this is crazy as hell, right? In a criminal case, Suge took a deal because it was his lawyers weren't representing him, said they didn't know his case. They wasn't allowing him visits. He lost his mama. He probably was spiritually broken. You know what I'm saying? He'd been shot right before that, right? And he's in jail dealing with all of this stuff. It's all of this stress on him. He see that they're now allowing him to find a counsel of his own, and he doesn't want 100 years to life. So the counsel that the judge forced on him, the counsel that was friends with the judge for 40 years, that was forced onto him, told him, look, take this 11 years and you'll be able to go home, or if not, you're gonna get this 100 years. He takes the 11 years, they enhance him for priors. His same attorney tells him to admit to the priors and don't worry about it, he's gonna handle it. He admits to the priors, listening to his counsel, and that enhancement got the man 28 years from an 11-year sentence, what he pled out to, right?
Setup.
It's cold setup, right? So, but in a criminal case, they have to prove beyond a reasonable doubt. A reasonable doubt is, well, hold on, maybe he was just fearing for his life, and because he's blind in one eye, and what side was Terry Carter on? Well, we know Bone was on the left side, so he probably could have even accidentally ran Bone over when the rear view mirror hit him or whatever, right?
Right.
This is a reasonable thing, so we don't believe he intended. The juror can reasonably say, well, we don't believe he intended to run Bone over. It could have been possibly accidental, so I cannot find him guilty as a reasonable doubt of intentionally doing that, right? Which means involuntary manslaughter. You're talking about 2 years, 3 years, 4 years. Even if they doubled that up, you're talking about 8 as opposed to 28 years. So he still be held accountable, but these are the different things that you have to do. Now, in the civil court, it's easier to get them to come to agreement. It's just preponderance of evidence. That means 51% more likely than the 49% of people that don't believe it. So if you could get, what was it, 7 jurors or nine of the 12 jurors to agree that that they believe like it happened in this case, and they couldn't even do that by the lesser one. So if that jury was in a criminal justice court, essentially Suge couldn't even been convicted on these charges. That's what they're talking about. You know what I'm saying? So in addition, a finding of a liability by only 9 of the 12 jurors was sufficient for a verdict, as opposed to a criminal case which requires a unanimous verdict by all 12 jurors. After lengthy deliberations, the jurors in the civil case were unable to reach a verdict. The civil trial testimony and outcome of that case is plainly new evidence that this court should consider in determining whether Mr. Knight has made a prima facie showing that he is entitled to relief. I'll let you start with the ineffective assistance of counsel.
All right, y'all. So we're at G, claim 7, ineffective assistance of counsel. Respondent characterized this claim as rising ineffective assistance of counsel stemming from petitioner's motion to rescue the 2 trial judges dated December 15, 2022. In formal response at page 47. It is urged that the claim lacks merit because it was filed in pro per. It was filed 4 years after the case was final, and it does not include new evidence that would support a claim for relief, and it is moot because neither Judge Braylon or Cohen has been assigned to decide the petition. All right, hold on a second. Okay, here we go. I bigged my screen and lost my place. Which page we on, Deuce?
Oh, hold on. Let me get back to it because I was in the chat. We're on page 43.
Hold on. Let me get there. All right. Okay, so I read that. So boom. All right. Respondent misunderstands this claim. The petition specifically alleges ineffective assistance of court-appointed counsel. Petition at 9. There was only one court-appointed counsel in the case, Alec DeBlanc. The petition cites Strickland versus Washington, 466 U.S. 66-8, 1984. The seminal case on an ineffective assistance of counsel, numerous state cases discussing ineffective assistance of counsel, as well as the 6th and 14th Amendment to the United States Constitution, right to counsel and due process of law, and California Constitutional Article 1, subsection 15, state constitutional right to counsel. Petition at 9. The memorandum of points and authorities in support of the petition also cites case law regarding ineffective assistance of counsel under the federal and state constitutions. See memorandum at 24 through 25. The petition and supporting memorandum contains numerous references to DeBlanc's ineffective assistance. In the context of Claim 3, it is alleged that the trial court-appointed public defender forced upon petitioner was ineffective because he did not investigate Mr. Knight's previous plea agreement. Petition at 5. Claim 4 alleges that Albert DeBlanc had only one reference regarding his ability. His friendship with Judge Cohen, that DeBlanc did not perform any duties on behalf of petitioner except to convince him he had no choice but to plead guilty in an unlawful, unwarranted second strike, and that DeBlanc should have excused himself instead of leaving petitioner defenseless in this matter. ID at 64, emphasis omitted. Claim 6 alleges that court-appointed counsel was forced upon him. He was coerced into a plea agreement. ID at 8. Claim 7 alleges Mr. Knight had made a prima facie showing of entitlement to relief because he suffered ineffective assistance of court-appointed counsel over his objection. ID at 9. In claim 8, petitioner states that he was given no choice by the trial judge and or DeBlanc but to accept a plea bargain / agreement. ID at 10. There is more. The memorandum of points and authorities in support of the petition also raises DeBlanc's ineffective assistance. The introduction alleges that appointed counsel failed and or refused to investigate, research, or put up a defense for petitioner. Memorandum at 1. Also see ID at 11. Failure to investigate the facts of the case and Mr. Knight's prior conviction. ID at 5. 16 through 17. DeBlanc effectively failed to investigate the plea agreement and conviction in 1994. It alleges that petitioner told DeBlanc he wanted to appeal, but DeBlanc failed to timely file a notice of appeal. ID at 3. What is that? Paragraph 11. Also see ID at 9. Petitioner asked court-appointed counsel to file a timely certificate of appealability and or of appeal, but DeBlanc failed to do so, and the appeal was rejected as ultimately. ID at 11. Failure to timely file certificate of appealability. Also see Exhibit 42, Exhibit 2, page 111 through 13. There is also allegations that DeBlanc did nothing for the petitioner except convince him that he had to plead guilty and leave him defenseless, and that his only loyalty was to the judge who appointed him. Memorandum at 18 and 19. I forgot what that was. Sorry. 1. Failure to investigate.
Hold on. Henny, remember when I was talking about Strickland versus Washington being the setting the standard for effective counsel and ineffective counsel, and I was saying that attorney has obligation to investigate all reasonable avenues of defense, right? Here it goes right here. That's what they're arguing. I mean, I'm just basically tooting my horn because I've been through this litigation, you know?
Well, toot-a-loot-a-loot on then.
But go ahead. Apologies.
No, toot your horn. All right. So here we are at failure to investigate, discover, and present exculpatory evidence. Ooh, my tongue cooperated just then. Hey, okay. DeBlanc failed to take even the most basic steps to investigate and prepare Mr. Knight's defense. As discussed in Section 5 below, the case file he provided to successors counsel contains no work product, i.e. communication with investigators, experts, his client or defense witnesses, investigators, or expert reports, no notes, no summaries of evidence or witness statements, no research materials, evidence outlines, or memoranda. Okay? He had nothing.
He didn't do shit for him. That's crazy.
Like, imagine that. Imagine you get a hold to information and it's blank. It's a whole blank folder. There's nothing there. Your life is in this person's hands and they playing with you. Exhibit 54. In sum, there is no evidence he had did any investigation, interviewed his client, or interviewed key witnesses. The following are just two examples of DeBlanc's ineffective failure to discover, investigate, and present exculpatory evidence. A. Danny Timms. At the instigation of the Los Angeles County Sheriff's Department, Timms was housed in the cell next to Mr. Knight's. Timms was provided with what he described as the murder book. Through this combination of proximity and case knowledge, Timms was to manufacture non-existent conversations with Mr. Knight and entirely false inculpatory statements supporting the prosecution's theory of the case. Then he was to falsely testify at trial regarding alleged admissions by Mr. Knight. Mr. DeBlanc knew of or should have known about Tim's. This evidence was discovered early on in the case in January of 2016 by John Moore, a court-appointed investigator working for Thaddeus Culpepper. Shaking my head. Exhibit 4, report of interview with Tim's. 44, transcript of interview with Tim's. So they done planted a snitch right next to him that was supposed to just set him up. Is that what I'm hearing? That's what I thought I heard. Okay. Competent counsel would have investigated, discovered, and presented evidence about Tim's. Reasonable investigation would have revealed egregious, there we go, misconduct by prosecution team's members in placing an informant next to Mr. Knight and providing that informant with details about the case, which were subject to a strict protective order preventing the dissemination of case material to all but law enforcement and members of the defense team. Reasonable investigation would have completely undermined Tim's credibility. So the footnote here says, during a September 19, 2018 hearing on pretrial motions, petitioner made a Marsden motion.
Remember I said when he should have said Marsden when they was telling him to shut up, he couldn't talk, all of that. That was the motion basically that is notifying the judge, no, it's Marsden, it's pertaining to my right to for counsel, etc. You're objected to the proceedings going further, where they have to stop right then and there, whatever else was on their agenda, and get to the bottom of what's going on. But he's letting it be known that what Suge was doing, he never said Marsden, but he clearly was doing turning it into a Marsden motion. But go ahead.
Okay, that's Exhibit 48 at page 175. A transcript of those proceedings has not yet been received. All right, so back to what we were saying. We were talking about undermining Tim's credibility. Cast serious doubt on the admissibility of his testimony, giving rise to a motion to exclude his testimony at trial, and at a minimum would have allowed the defense to effectively challenge his credibility if he was called as a trial witness. Even if the prosecution didn't call Tim's at trial, he could have been called by the defense to show that the investigating agency was willing to suborn perjury to convict Mr. Knight and demonstrate that the agency's animus, I can't say that word.
Yeah, they probably put animosity,
but it's animus towards him. Thank you. I couldn't say the word. B. So we back at Ayatollah Marv, y'all. DeBlanc failed to interview Ayatollah Marv, whose testimony at the civil trial is summarized in connection with Claim 6 and fully set forth in Exhibit 35, which are incorporated by reference herein. Law enforcement interviewed Ayatollah Marv and provided the details of what he said to the defense. See Exhibit 45, transcript of interview with Ayatollah Marv on March 21st, 2015. Ayatollah Marv's testimony was critical because it established that Cleystone Bone had a gun at the time of these events. The significance of this fact cannot be understated. Competent counsel would have investigated and presented the testimony of Ayatollah Marv. There could be no tactical reason for DeBlanc's failure to do so. If he had performed competently, he would have discovered this evidence, called Ayatollah Marv at trial, and at least one juror would not have convicted petitioner. He would not have coerced his client into a plea by telling him he would lose. If he lost, he would never get out of prison. Petitioner was prejudiced by his lawyers' failure to investigate, discover, and present testimony from Ayatollah Marv. In the civil case, the jury heard Ayatollah Marv testify and was ultimately deadlocked 7-5 on issues of negligence and battery. The jury's failure to return a non-unanimous verdict in the case where the burden of proof was preponderance of evidence demonstrated the persuasive nature of his testimony. It is reasonably probable that had DeBlanc been prepared and tried this case, at least one of the trial jurors would not have voted to convict Mr. Knight. See the conclusion. The trial counsel's duty to investigate is well established. C.E.G. Sanders versus Rattel, 9th Circuit, 1994, where trial counsel failed to conduct even the minimal investigation that would have enabled him to come to an informed decision about what defense to offer and whether to call certain witness. Trial counsels failed in this case, evidenced an gargantuan indifference to the interest of his client and clearly prejudiced the case defense ID at 1,444. Damn, that's how. Anyway, under the Sixth Amendment and Article 1, Section 15 of the California Constitution, a defendant in criminal case has a right to the effective assistance of counsel. This right entitles the defendant not to some bar assistance, but bare assistance, but rather to effective assist. Okay, and then they give you cases that they are referencing. So the state differently, and defendant is entitled to the reasonably competent assistance of an attorney acting as his diligent conscientious advocate. The presumption that counsel's conduct is within the wide range of professionally competent assistance does not excuse counsel's failure to investigate and prepare a defense. See Turner versus Duncan. Any presumption that petitioner's counsel exercised reasonable professional judgment is rebutted because counsel's omission in this case were not informed tactical decisions, but decisions that resulted from lack of diligence in preparation, investigation, and conclusion with his client, consultation, with his client.
Hold on, Henny, before you even finish this, I just really got to interrupt. If you look at the comment, Shorty Doo-Wop said to y'all, hi to y'all, I hope Henny likes short niggas, Memphis on the check-in.
Well, I'm short.
Gaining for Henny.
I got the shorts for Henny.
I mean, I'm a short woman, so I don't know.
How short you like him? 5 foot or 4'11"?
No, neither. You got to be at least 5'8", 5'9", somewhere. I'm 5'3". What am I gonna do with somebody who my height?
Okay, he could be 5'5", 5'6".
He might be 5'3" and buff. He can lift that thing up. Oh.
Listen, I don't know. I've never dated a short man.
Right.
So I don't know the answer to that one.
Okay, I get it. So we're gonna look for more being of more stature. All right, come on. Pardon the interruption. I just couldn't help myself. Yeah.
I bet. Right. Now you done made me come up off my screen. Now I got to go all the way back to where I was. I'm at 47. All right.
Extent, I think you was at to the extent of any of the errors, the last paragraph.
Okay. Yeah, because we was talking about the diligence and preparation, investigation, and consultation with his client. All right. To the extent that any of the errors and omissions alleged here were tactical decisions that were unreasonable, any attorney's strategic choice made after less than complete investigation are reasonable precisely to the extent that reasonable professional judgment support the limitations on investigation. There is no reasonable professional judgment supporting DeBlanc's failure to prepare, investigate, and consult with his client. But for the ineffective errors and omissions of counsel in this case, it is reasonably likely that Mr. Knight would not have pled no contest, would have gone to trial, and at least one juror would not have voted to convict him. 2, constitutionally insufficient communication with client. The trial court appointed DeBlanc to represent Mr. Knight as standby counsel on November 14th of 2017, Exhibit 18, page 128. and as sole counsel on March 23rd, 2018. Exhibit 20 at pages 169 through 70. Less than 6 months later, on September 20th, 2018, Mr. Knight pled no contest. Exhibit 47. During the entire time, DeBlanc represented petitioner. He visited him at jail on 2 occasions. Exhibit 34 at pages 35. These visits were brief, each lasting for about 8 to 10 minutes. During these 2 visits, there was no discussion of case, no discussion about prosecution's evidence or witnesses, no request that Mr. Knight tell him what happened that day at Tam's, no inquiry as to any witnesses known to Mr. Knight, and no inquiry into Mr. Knight's perspective regarding the prosecution's case. Rather, the visit consisted of pleasantries and ended abruptly by DeBlanc telling Mr. Knight that he needed to see other clients. Pause. You didn't have no conversation with him either at all about nothing. You're having pleasantries like you on a visit with your friend.
Yeah, but think about it like this. If that's my lawyer, one thing I do know for sure is the people that I know that was there. I know Terry Carter, that was my friend. I know Ayatollah Marv, that was my friend, right? I seen them at the car. They're on the camera. So if you're my attorney, why didn't you ask me, well, who else do you remember that was there that might be a witness to facts that'll be beneficial in putting on your defense? Why? Let me go see what they got to say, and they might say something that be against you, so I don't use them. But if I don't know whether they got something that's going to help you or hurt you until I at least go first talk to them. I never talked to you about who do you remember there? What had happened? The way that I'm going to try to attack this, because in his mind, he already has sold Suge out.
But don't the lawyer also have to tell you what motions they plan to do, how they plan to proceed? They've got to interview you, get your side of what happened, and actually prepare you for trial, prepare you for court, period.
Right. None of that got to go. Suge said that, and I'm quite sure his attorney, his so-called attorney, that's not an attorney, his attorney told him, I'm going to get an extension. This is when the trial finna start. Right. And he's like, oh, okay. So, he's thinking that it's just going to get put off again. And the judge denied the extension. Right? So the judge denies the extension. He told Suge, I'm not prepared for trial. I'm trying to get an extension because I'm not prepared. And the judge said, well, we're not giving no more extensions. We're going to push this. It sounds like good cop, bad cop with me. Remember, this is the same lawyer that's been friends with this judge for 40 years.
It's like I was telling people last night. We were talking about something in one of my members' chats. And we were talking about lawyers and how they have relationships with other lawyers and judges. And they don't necessarily have to meet in chambers. They don't have to go to the lawyer's office. You know how they make these deals? They go to the golf course. They go to the bar. They go to a steakhouse and have dinner. They invite them over to the house for a barbecue or a get together. And there they discuss things.
Or they can donate to their charitable organization.
Right.
When
there's something like this going on, it's definitely quid pro quo between the lawyer and the judge. That's my opinion.
Yeah, I'm with you.
So petitioner's extremely limited contact with DeBlanc denied him the right to consult with his attorney, to know the evidence against him, and to contribute to his defense. Before DeBlanc was appointed, Mr. Knight had informed the trial court on at least 2 occasions that he had never seen any discovery. Exhibit 17 at page 166, Exhibit 20 at pages 167 through 68. This situation was not remedied or even slightly
ameliorated. I wonder what that means.
We're going to look that up.
Yeah.
Hold on, I got you. You know I'm good for doing that. If I don't know a word, I'm gonna go look it up.
Yeah, I definitely don't know it. Let me ask. See, I might be able to get Ayatollah Marv if he ain't busy, and I'm gonna ask him real quick. Tell him we just went through this, and do he believe that since they had a hung jury in the civil trial, do he believe that his testimony would have at least got one juror to believe not to convict Suge? Let's see what's going on.
So ameliorate is past tense, right? Well, the past tense is ameliorated, all right, which means make something bad or unsatisfactory better.
Yo.
I told him, Marv, what's up, big homie?
Man, I see you over here putting heat on these niggas, man.
Oh, yeah. Well, we ain't going to talk about that now. I'm live right now. We breaking down the habeas corpus motion for Suge, right? And it went into the civil, your testimony at the civil trial, and how the counsel never even asked Suge, was there anybody there and who was there so that he could go investigate whether you could have provided that during trial. Do you believe?
But
yeah.
The crazy part about it, G, they knew about it.
Right.
His attorney, Larson, I dealt with, what's his name? It's in the pen now. What's the black boy name that they arrested? Not Abercrombie. Culpepper. I first started talking to Larson. Then it was Jason Toussaint. I've been in contact with all of his attorneys. This prosecution Biddle, the detective Biddle, kept our shit quiet, right?
Wasn't Biddle the same one that was the prosecutor or detective on when he got shot at 1-0?
The detective Biddle, the same information. I think I sent you the police report. On that other guy. And Biddle was behind this whole thing, and he made sure that we stayed out. Every time our attorney, when Larson and them came on, they systematically, like I say, went through 14 attorneys. The only two that got prosecuted was Fletcher and Culpepper. All the white boys, nobody got prosecuted. All of them, there's some more shit behind that. But,
right.
Yeah, I was right there. Matter of fact, what's the public pretender's name? When they were supposed to go to trial, I told them, man, look, I'll tell you what happened. And they was like, oh, okay. Man, I'm going to be down for win, lose, or draw. I'm going to be down for a homeboy.
Right.
Just like I'll do a drive-by for him, I'll testify for you.
Facts.
So you can call it what you want to call it, but I'm not letting a Pyru go down for some shit he didn't do. And it was an accident. I can show where it was an accident. He never, Terry got out of the car trying to help Suge.
Damn. Well, I'm going to call you back because we live, but we definitely wanted that one quick question before you go, and then we'll talk later after I get off about how I've been pressing the line on these pussies, right? But do you believe, had that information been available during trial, that at least one juror would have found Suge Knight not guilty?
Look, first of all, before you can handle anything, the biggest part is you have to show intent. There was no cause of intent because Suge was assaulted and was trying to get away from a scene. They cannot show no intent that he intentionally tried to harm anybody.
Right.
And if you can't prove intent in jury deliberation, they have to show vehicular manslaughter, any aggressive crime, you have to show intent. He never came with the intent to do harm to anybody. He was aggressed upon and was trying to flee the situation.
Facts. That's what it appears to me also.
No way he would have got convicted. And as you said before, if he had got involuntary manslaughter running over somebody, that's 7 years. How you get 28? I'll tell you that later.
Right. All right. We definitely gonna talk about it, big homie. Love you. Salute. Enjoy the rest of your day.
For sure.
All right. Yeah, man, that's one of my big homies, one of my dad friends since 1983, 84. I only knew him as Big Mess. This new Ayatollah Marv on the internet is something different. Y'all met him through that. I know him as a friend of my family. Big Pyro. Shout out to Bompton. You know what I'm saying? But as we were, Henny. You know what I'm saying?
Just throwing it out there. You know, I wanna pick his brain. So we should.
I'm gonna set that up. Promise you, that's set up already. You got that.
Copy. All right. So we were leaving off with hold on, where are you at?
Ameliorated.
We both get it. So that means to make something better that was wrong. So now we done learned a new word. So let's try to put that into our vocabularies. Now we are at 48. All right. So DeBlanc had a duty to consult with petitioner on important decisions and keep him informed of important developments in the course of prosecution. Strickland versus Washington, 466 U.S. at 688. All right, they're giving you some cases. I'm just going to skip over those for now, if you don't mind, Deuce, because those kind of like drag it out. These constitutional imperatives. I gotta reset.
Right. Got it.
Y'all gonna leave me alone about that too. I done told y'all that happened after I had anesthesia. My tongue be all in the way and I feel like I can't say the word. All right, so anyways, we're not met in this case. Given the serious charges, DeBlanc's 2 visits to his client, each for a brief time, failed to comport with reasonable professional norms and practices. Shaking my head. All right, so damn it, every time I move this, hold on, give me a second, y'all. I ain't coming back over here to the StreamYard. I'm staying where I'm at. Yeah, because every time I do, it moves me for whatever reason. All right, so now here we are.
At the bottom of 48.
Investigations. Right here. I read that. Decisions informed. Okay. Slightly enamored. I lost my place. Okay, here we are. So petitioners extremely limited contact with DeBlanc. Okay, that's where we are, right?
Right.
Petitioner's extremely limited contact with DeBlanc denied him the right to consult with his attorney, to know the evidence against him, and to contribute to his defense. Before DeBlanc was appointed, we read that already. He informed the court twice.
Well, you was at the part where it was given the serious charges. DeBlanc's 2 visits to his client, each for a brief time, failed to comport with reasonable professional norms and practices. Right at the bottom of page 48. And then, I'll take over. And then
I got it.
Okay. You see page 48?
I'm at 48. I'm on 48. The bottom of it says DeBlanc coerced petitioner to plead no contest because I'm on the right page. Okay.
DeBlanc. No, it was DeBlanc had a
duty to consult with petitioner on important decisions to keep him informed of important developments in the course of prosecution. Okay. These constitutional imperatives were not met in this case. Given the serious charges, DeBlanc's 2 visits to his client, each for a brief time, failed to comport with reasonable professional terms and practices. All right, there we are. All right, so it says reversing first-degree murder conviction. This is based off of the what they have here. First-degree murder conviction for ineffective assistance of counsel were inter alia. Defense attorney conferred with his client 3 times over the course of their entire relationship for a total of somewhat over an hour at best. So that's what happened in that case. All right. So 3, DeBlanc coerced petitioner to plead no contest because he was not prepared for trial. So because he ain't do what he was supposed to do, he says he gonna put it off. But I don't believe that that's what happened. I believe that's just what he said.
Right.
Pre-trial motions filed by the prosecution were heard on Wednesday, September 19th, 2018, Exhibit 48. Just before the case was adjourned, there was a discussion of petitioner's suit size and an what happened? Admonition. Now that word I didn't know. For the court that the parties were to appear at 8:30 a.m. on September 24th. Because the jury would be there at 9 a.m., Exhibit 48, page 189, DeBlanc informed the court that he needed to spend a little time with my client. The next day, September 20th, 2018, the case was advanced and DeBlanc announced that there was a negotiated settlement. Mr. Knight's plea was not knowing, voluntarily, or intelligent, but was the product of coercive. Thank you. Pressure by DeBlanc. DeBlanc, who had previously assured Mr. Knight that he could obtain the continuance of the September 24th trial date, he could trial date so he could learn the case, informed him that there was not going to be a continuance and trial would start on Monday. He told petitioner that if they went to trial on Monday, he would lose, and that if he lost, he would be sentenced to 100 years and die in prison. What words to speak over somebody? That's like so harsh. At its core, DeBlanc's message was the trial was a doomsday scenario. He was not prepared, did not know the case, and Mr. Knight would die in prison if he went to trial. DeBlanc told petitioner falsely that even though the proposed deposition sentence was 28 years, because of his age and other things, he would be out soon. Wow, your lawyer's speaking death over you? Like, that's nasty work for real.
Yeah.
Okay.
Let me see. I ain't even in the chat. I'm over here reading. This is crazy.
Okay. Mr. Knight was not. Okay. I read that part.
DeBlanc's ineffectiveness was not limited to lack of investigation. It was the bottom of page.
Yeah, right here. It's right here. I got it. It's line 20. DeBlanc's ineffectiveness was not limited to lack of investigation and preparation. Mr. Knight is blind in one eye and has very reduced vision in the other, making it difficult for him to read. DeBlanc did not read the plea agreement to Mr. Knight, much less explain its terms. Instead, he left the room and had court bailiff, a sworn Los Angeles Sheriff Department officer, just like the investigating officers in the case, read the plea agreement to the petitioner. The bailiff, however, well-meaning, had no legal training. He could not and did not provide any clarification of the terms of the plea. That's like having me read it to him. I don't know these terms. The record does not show that DeBlanc, this is the footnote, the record does not show that DeBlanc filed any pretrial motions on behalf of Mr. Knight.
God damn. He didn't even file no pretrial motions. Damn.
It gets worse the more we read. You know that, right?
Yeah.
Okay, so we left off with he could not provide any clarification to the terms of the plea agreement or engage in discussion of the terms. DeBlanc abdicated his duty ensure. Mr. Knight abdicated his duty to ensure Mr. Knight understood the terms of the plea agreement, and Mr. Knight entered into an agreement without adequate legal guidance on the specifics or consequences. Mr. Knight's failure to understand the plea agreement, as well as DeBlanc's lack of preparation, were demonstrated during the plea colloquy. The court asked if Mr. Knight admitted to admitted to prior convictions, and he responded no. DeBlanc then told the court that the defendant questions that particular prior. Can you run that? I thought I had it, Your Honor. Can you give me the date? The court informed DeBlanc, who appeared to be as unfamiliar with the plea agreement as he was with the facts of the case, that the convictions were on February 28th, 1977 in Los Angeles for assault with a firearm resulted in a 9-year sentence. The court asked petitioner, do you remember that? He said no. DeBlanc then conferred with Mr. Knight in the courtroom for an unknown amount of time. Thereafter, Mr. Knight admitted the prior conviction. According to Mr. Knight, DeBlanc told him that he had been doing this for 40 years, that he would go into chambers away from the cameras and get it straight, that Mr. Knight would not have a strike, that it would be taken care of, and guaranteed that he could fix his priors. This representation was patently false. Failure to file notice of appeal and application for certificate of probable cause. In order to appeal Mr. Knight's judgment of conviction on issues going to the legality of the proceedings, a written statement under penalty of perjury showing reasonable constitutional, jurisdictional, or other grounds for appeal had to be filed in the trial court within 60 days after rendition of judgment, i.e. by December 3rd. That's my birthday. 19. I was about to say my birthday. December 3rd, 2018. Then within 20 days, the trial court was to execute a file of certificate of probable cause to appeal. DeBlanc ineffectively failed to file a notice of appeal until March 13th, 2019. DeBlanc, whom Judge Cohen described as an experienced criminal defense attorney, he knew or should have known the rules for filing an appeal after a plea of no contest. He was required to file a statement of grounds for appeal within 60 days after October 18th, 2018. DeBlanc incompetently failed to timely file the documents necessary to do so. Mr. Knight did not know an appeal had not been timely filed until he received an order from the Court of Appeals dated April 25th, 2019, dismissing the appeal because it was untimely. The letter from petitioner to DeBlanc stating, it has come to my attention that the notice of appeal was not filed by you in a timely manner. That's dated May 22nd, 2019. That's in Exhibit 7. Once the appeal was dismissed, DeBlanc made no effort to remedy his failure to timely file a notice of appeal. Such a filing, a petition for writ of habeas corpus seeking relief from his error. Okay. People versus Barlow. I think
all of that is just
California. Yeah, that's all case stuff. Yeah. California imposes on trial counsel a per se duty to consult with defendants about the possibility of an appeal. The United States Supreme Court has held that counsel has a constitutionally imposed duty to consult with the defendant about an appeal when there is reason to think either 1, that a rational defense would want to appeal, or 2, that this particular defendant reasonably demonstrated to counsel that he was interested in appealing. All right. And then you got some more case stuff in there that backs up what they were saying. Because Mr. Knight requested an appeal and his attorney failed to timely file an appeal to his conviction must be reserved. You want to take over from here?
First, yeah, I got you. His conviction must be reversed. 5. To this day, DeBlanc has failed to provide his complete case file to Mr. Knight and his counsel. So now he has counsel representing him. And not only did he fail to file his appeal and all of that, the new counsels tell him, hey, bro, you still got to turn that file over. He got representation. I'm finna file a habeas corpus petition. You need to help me get this going because you done fucked up this dude's rights, right? DeBlanc disregard of his professional duties toward Mr. Knight continued after he failed to file a timely appeal. On March 23, 2019, petitioners sent the letter to DeBlanc asking for his case file that was logged as outgoing legal mail by the R.J. Donovan Correctional Facility, Exhibit 50. There is no record of any response by DeBlanc, Exhibit 55. 2 months later, on May 22, 2019, Mr. Knight asked that DeBlanc to provide all files, discovery, etc. to Dermot Givens, attorney at law. And then it has the address of Beverly Hills lawyer, right? And phone number. He informed DeBlanc that Mr. Givens was working against a time restraint and it was extremely important that he receive the files as soon as possible. Exhibit 7. DeBlanc did not respond to this letter. Exhibit 55. On May 19, 2022, a motion by Mr. Knight that DeBlanc provide him with a copy of his file with the understanding that the current protective orders in effect will stay in place was filed in this court. This motion was calendared for June 2nd, 2022. The online docket shows that proceedings were held on that day, but the minute order is, and then here it goes. Ex parte motion, defendant Knight's notice of motion and motion allowing Mr. Knight's prior defense counsel, Albert DeBlanc, to turn over to undersigned counsel a copy of Mr. Knight's file with the understanding that the current protective orders in effect will stay in place. Declaration of David E. Kenner is received and filed this date. The court sets this matter on calendar for June 2nd, 2022 at 8:30 a.m. in Department 101. A copy of this minute order is forwarded via email to Albert DeBlanc, attorney Cynthia J. Barnes, Deputy District Attorney Tomas A. Gutierrez, and attorney David Kenner, attorney. Listen, this dude was put on notice, and Kenner and them were so smart to make sure, because he's not responding to Suge, nigga, sit your ass up in there and do that 28 years. That's what he left him to and left him with without even responding to him or his obligations as an attorney to try to appeal to get him off of this injustice that he promised he wouldn't get because he was going to take care behind closed doors the prior so he wouldn't get in hands. He done left this man without it, but Kenner and them made a record and it's on the docket, the court docket, and this dude still hasn't sent the files. Wow. On May 8th, 2024, Mr. Knight, through attorney Jasmine Mines, requested his entire client file from DeBlanc. Jasmine Mines, Compton girl. Hey, Jasmine. But anyway, on May 22nd, 2024, Ms. Mines emailed DeBlanc a copy of the letter dated May 8th, 2024. DeBlanc did not respond. On May 30th, 2024, Ms. Mines emailed DeBlanc requesting his entire file. DeBlanc responded. Oh, he finally responded in June 1st, 2024, by requesting confirmation that she was counsel of record in this case, even though she had already informed him she represented Mr. Knight. So now he can't even say that he didn't get the other request because she continued contacting this dude, requesting this stuff, and then he finally answered months later, right? So this was a good address and email and everything else, right? For this purpose, you decided to get back. But all of these other things and the time constraints that he was dealing with his appeal and all of that, you didn't think it was worth even getting back.
Exactly.
So they got him. He's a piece of shit. On June 2nd, 2024, DeBlanc asked Ms. Mines to provide him with an external drive to transfer the files. That same day, she purchased an external drive and had it sent directly to DeBlanc for delivery the next day. On June 3rd, 2024, after confirming that the external drive had been delivered, Ms. Mines emailed DeBlanc asking when the external drive would be ready for pickup. His response was to ask for her telephone number. Let's get into this footnotes. This letter defined complete file as follows: pleadings and court filings, all complaints, indictments, and other charging documents, copies of all motions, briefs, memoranda, and other court filings, orders, judgments, and opinions issued by the court, transcripts of all court proceedings, including hearings and sentencing, if applicable for the duration of your representation, correspondence, all correspondence between your office and myself, including letters, emails, and notes from phone conversations, correspondence between your letter and the prosecution, court officials, and other parties related to my case, letters and communications with any investigators, experts, or witnesses involved in my defense, discovery, copies of all discovery materials received from the prosecution, including police reports, witness statements, and forensic reports, USBs, CDs, etc. I thought that they said the wiretaps, they give them to you on CDs or transcribed wiretaps as paperwork weren't paperwork. I thought they weren't part of discovery. These dudes don't know what the hell they be talking about. That all of that is part of discovery. That's the paperwork. So all discovery materials provided to the prosecution, any notes or analyses related to discovery materials, investigative materials, reports and notes from any private investigators or experts hired on my behalf, if any, evidence collected, including photographs, videos, and physical evidence, summaries or transcripts of witness interviews and depositions, legal research and notes, research materials, legal memos and notes prepared in the course of my representation, strategy notes, preparation documents, and outline, any internal communications or notes related to the case strategy and planning, miscellaneous, any other document, notes, or materials that were part of my case file or were created or received during the course of your representation. All right, so now we can get back to this. On June 10th, 2024, Ms. Mines wrote DeBlanc again asking when the drives would be available. How many days have passed now since the first one? Man, 8 days later, this dude talk about, can you call me? DeBlanc did not, I sent you the drive. I spent my money, my resources to get this off of you because you've been holding on to it. You're not responding to us. And this is how unprofessional DeBlanc was. So DeBlanc didn't even respond when she said, when will you have the drive available? This is 8 days later. 10 days after that, a motion to compel production of client file, declaration of Jasmine Mine Esquire, declaration of Marion Knight, proposed order was filed, Exhibit 51. It was not until August 12, 2024, that DeBlanc represented that the discovery has been made available for pickup and the matter was taken off calendar. So you talking about from June 8th to August 12th, July, August. So 2 months later, after she done paid to get the hard drive there, when he acted like that was the only holdup, was he needed an external hard drive for all of the stuff to go on there. And in 2 months, he still find a way to waste 2 more months, even though they got court hearings and dates and all of this. The hard drive provided by DeBlanc does not contain the entirety of his file. Then he gives it to her, and it doesn't have the entirety of his file. No work product has been provided to successor counsel. There is no correspondence between DeBlanc and petitioner, the prosecution, the court, or other parties relating to this case, nor is there evidence of any communication with investigators, experts, or defense witnesses. There is no investigator or expert work product such as reports, photographs, or witness interviews. There are no summaries of witness statements or the evidence in the case. There are no research materials, legal memos or notes, evidence outline, etc. There are no notes of interviews with petitioner. There is no indication DeBlanc provided reciprocal discovery to the prosecution. There are no transcripts of any proceedings in this case. Exhibit 54.
Hold on, I got a question.
Go ahead.
He sent her a blank external drive that he asked for?
No, he sent her like probably just simple stuff like the investigative report from the police. But as far as evidence of investigative work that he might have done on behalf of Suge, evidence and notes of interviews that he might have done with potential witnesses, he didn't send none of that. Any letters that Suge sent him asking for his stuff or whatever, he didn't send her none of that, right?
Shake my head.
Yeah,
disbar his ass. Disbar him.
Yeah, they definitely need to report him to the California bar. All right, so then it goes into law about the termination of representation for any reason, right? And then it's all law. 8, counsel errors. This is the 8th argument. Counsel's errors and omissions individually and cumulatively prejudice the petitioner. It was so much that individually each one of these might not have prejudiced Suge from getting a fair trial and resulted in illegal sentence and or conviction, but all of it together was just too much, and that's what resulted in prejudice prejudice the petitioner. These errors and omissions by counsel individually and cumulatively so infected the proceedings in this case that petitioner's plea of no contest and sentence violates his right to due process guaranteed by the 14th Amendment and his 6th Amendment right to the effective assistance of counsel, Thompson versus Calderon. But for these errors, petitioner would not have pled no contest and would have not have been sentenced to 28 years in prison. Competent counsel would have investigated the prosecution's case, identified and presented defense witnesses, including experts, taking the case to trial, and as evidenced by what happened in the civil trial, petitioner would not have been convicted. 9, conclusion. The allegations in the petition and supporting memorandum allege that DeBlanc did not provide constitutionally effective representation to the petitioner, C-34, and then they go into Strickland versus Washington. Respondent has not addressed these claims. Petitioner contends that a prima facie case has therefore been established. This court should grant petitioner the relief he seeks as to this claim, or in the alternative, order an evidentiary hearing. H, Claim 8, California AB 1618. Petitioner submits this claim on the pleadings. Claim 9, the recusal of Judges Brandlin and Cohen. The argument that Judges Brandlin and Cohen should be disqualified from deciding this habeas petition is moot because neither Judge Brandlin nor Judge Cohen has been assigned to hear this case. Conclusion. For the reasons set forth herein, petitioner respectfully requests that the court grant his petition for writ of habeas corpus as to Claim 2, the violation of his right to represent himself, Claim 4, the denial of his right to retain counsel of his choice, and Claim 7, ineffective assistance of counsel, because respondent has failed to address these claims. Alternatively, he requests that the court issue an order to show cause why the relief he seeks should not be granted as to all claims, grant him access to the court's process to obtain relevant evidence and secure the presence of witnesses, and conduct an evidentiary hearing at which he can present witnesses and further documentary evidence in support of his claims. Dated January 5th, 2025, respectfully submitted, David E. Kenner, Marsha A. Morrissey, attorneys for Marion Hugh Knight, also known as Suge Knight, also known as Sugar Bear. And that right there concludes the reading of the motion for habeas corpus petition and how they railroaded Suge Knight and so many brothers incarcerated today that were railroaded, that don't have the voice or statue in the community and in the media, entertainment world that Suge has. If Suge wasn't as big as he was, he would have just been another nigga that got railroaded by the system. Let's speak on all of that now.
You know, like you said, there are people who go before the justice system every single day. And if this type of railroading is going on with Suge, Imagine how many people are sitting in jail that were not given proper due process on their cases, or their lawyers just didn't pay attention to them because of whatever reason. And let me tell you something, those court appointed lawyers, you definitely never want to really trust them. I mean, some of them, very rarely, some of them will do their job. I had a situation with my son when he was younger. He had a court appointed lawyer, and I did the work for him and made him. You need to call this witness. You need to do this. And, you know, I had my dad helping me, but I had to do the work for him. But imagine if we had a system that actually did what it was supposed to do. Imagine how many men are actually sitting in a cell right now thinking they had motions filed, they had things done on their behalf, and then they discover that they didn't, and they don't have the money. They don't come from being able to get another lawyer to come look at their case. This is nasty work. This was sad to see. This felt like a personal vendetta. And I feel like all parties involved in this need to suffer the consequences of their actions. From Biddle to Cohen to DeBlanc, all of them.
Yeah. Yeah, you with us?
Yeah, man, just to follow up and from the whole reading of this, man, it's just from setups to lies to, you know, putting innocent people in jail. It's nasty work all over, man. And the fact that Suge Knight is sitting in jail because of his lawyer not giving a fair due process, on top of, you know, just mishandling him, bro. At the end of the day, he's a human, you know, and you put your life in the hands of these lawyers and these DAs and the justice system, and goodness, man, it just brings me back to, you know, my friend and everybody who's going through this, man. You know, Freddie Sanders, Suge Knight, anybody that's going through this, man, is unacceptable, and we need to do better. That's why I vow to use my platform to help individuals like this. You know what I'm saying? So whatever we can do to help, this is what we're doing.
You know, and the thing, after reading this paperwork, a lot of people were under the assumption of what was put out there, right? That, oh, he ran some dude over with a car. That's not what happened. That was an accident. So it's like this clears a lot of things up for a lot of people. And to know that this man lost his parents, like that right there for me is the most heartbreaking and gut-wrenching. His mom just tried to go see him and was denied, and then passes away. And I don't know if they even allowed him. Did they allow him to go to the funeral? I don't know if they said or not.
No.
So you don't even get to see your mom go to her final resting place. Like, you just denied and stripped of all human rights. That's what we're seeing. Is somebody stripped of all basic human rights, even though once you're incarcerated, they say you have no human rights. You have no rights in there. You're still a human being. And that's just disgusting to me.
Yeah. Yeah, it's definitely disgusting. But one thing that's obvious to me is that Suge Knight got a lot of powerful enemies, right? And when I say powerful enemies, you're talking about Jimmy Iovine, who is one of the most powerfulest people in the music industry and partial owner and founder of Beats by Dre, right? You're talking about billionaires. Then you got Dr. Dre, obviously, right? Who they're saying is the one that's supposed to hire Bone to do this to Suge, right? So all of this starts not at the behest of Suge, right? But at the behest of these powerful people. And if we're gonna be really getting into the Rampart scandal, we're gonna really be getting into the hip hop cops to show how these dirty law enforcement agencies, DEA, FBI, we know about COINTELPRO, but how many of y'all know about the Black Desk? Google COINTELPRO and the Black Desk, right? Which is primarily targets and focuses on melanated people, melanated peoples in the inner cities, in their communities, right? Their leadership. Knock off the head, the body falls. It's preordained and destined by the laws of this land and their agenda to make sure that you don't have fathers in these households, right? You don't have strength and balance in these households to raise that next generation. So we're definitely going to be exposing all of that corruption and how that trickles over to politics, and then the practical application of that corruption in cases specifically just like this one with Suge Knight. We already been live for I don't know how 2 hours, so we gonna go ahead and end this one because I know tonight I'm probably gonna go live again, but we got some business to take care. But to all inmates, we're gonna try to start getting our content on Hip Hop DX, especially when we got breaking and great content. But any inmates incarcerated, and I don't want you brothers that's faking innocent because you just want to go home, you miss your girl. I get it, and I wish y'all do go home. But if you've been falsely accused of a crime that you didn't commit, railroaded in similar situations, and you got proof thereof, holla at me, DM me. We would love to highlight, not running the whole content on each one, but we would love to highlight your case and that injustice and be that voice out here that you don't have in there. So you could go send it to activechucks@gmail.com, or you could go to activechucks in my DMs, and we can work out to get that. I'll post it on activechucks.com. If I go over it and I see the injustices, and I might even bring it up and break down the case and how you got railroaded if it was that malicious and obvious, just like this Suge case is. Till the next time, let them know where we at, y'all, and then Henny gonna take us out.
Man, listen, y'all is tuned in for 2 hours, man, with some hot content, man. Yeah, go ahead. You guys are tuned into this hot content, man. Listening to these receipts being read off, seeing the injustice that had happened behind a public figure like Suge Knight, and a lot of other brothers, man. And what we want to do, Do Sims, That Girl Henny, and myself, raising awareness all around the community, being the voice of the culture, and for the West Coast, and not just the West Coast, everywhere. Thank you guys for sitting through this content. Make sure you like, comment, subscribe. Tell a friend, tap in. Salute to our supporters, valid supporters that's in the chat. The Blue Wrench Mob that's always on their job. Y'all know the chat is where it's at. Again, y'all was just tuned in one of the dopest lives on YouTube. Do Sims, Bremen M, That Girl Henny, Yael, the Keyway pop star. This has been Damu Keyway Conversations.
All right, y'all. So it's not nighttime, but don't worry. Y'all, thank y'all for tapping in, tuning in. Be sure y'all smash that like button on the way out high so that the bullshit don't stick, and we'll see y'all in the next video. Peace, y'all.